Okay, thank you very much. Ladies and gentlemen, hello from Moscow. And as you were just told, there are two speakers today. So myself, a patent attorney and a senior lawyer, Evgeny. So in my part of the presentation, for my part, I've picked several topics relating to patenting biopharmaceutical inventions, which may be of interest for this audience. And then after I'm done, Evgeny will move on to discussing legal issues and the topics he has selected. So without further ado, let me start. Here's the title of the talk. And speaking of Eurasia, just as an initial note, I'd like to say that as most of you or all of you probably know, in Russia, just like in Germany, you can get a European patent and German patent. In Russia, you can also apply either to the Russian Patent Office and get a single Russian patent, or you can apply to the Eurasian Patent Office. And since Russia is a part of the Eurasian patent system, you can get Eurasian patent where Russia is a contracting state. The Eurasian patent system is for inventions only. Actually, we did not plan to make the comparison between Russia and Eurasia part of this presentation. However, whenever there are differences, whenever there are differences, I'll try to mention this. In my presentation, I'll focus on three main things. The bulk of my presentation will deal with the matter which is put here with a question mark. What defines the scope of biotechnological invention of pharmaceutical interest? Biotechnological invention claim. I'll give you some general information about what is expected to be in the claim as far as legislation is concerned. Then I'll discuss the drafting of a claim in case of most popular subject matters like DNA, proteins, and microorganisms represented by host cells. I'll give you an example of granted claims as well. And I'll also mention industrial applicability matter, the way the industrial applicability, the compliance with the industrial applicability criterion is evaluated in the Russian Patent Office, because this approach is somewhat peculiar. I'll finish my presentation with giving you some information on patent term extensions and data exclusivity protection, because both of them deal with medicaments and therefore will be of interest for this audience. I think the best place to start this kind of talk would be to say what is not patentable in Russia and Eurasia. And here are the lists of things not patentable. Of course, these lists only concern biotechnology, biomedicine. They're not exhaustive. You will not see things like scientific discoveries or mathematical methods here. I will not bother you by reading through these lists. You can see the items are pretty much not surprising, like methods for cloning humans, methods for modifying genetic integrity, use of human embryos for commercial purposes, other solutions contradicting public interests, and plant varieties and animal breeds. In Europe, they say, for example, essentially biological. Here we say just biological method for plant varieties and animal breeds. Probably some of you will be surprised not to see methods of treatment and diagnosing, but this is the case. In Russia and Eurasia, this kind of subject matter is patentable. As far as the right-hand side of my slide is concerned, this is Eurasia, and pretty much the same things as in the left-hand side. For those of you who are interested in reading through it, the presentations will be available online. All right, so as for general information, not surprising, in both jurisdictions, the patentability criteria are the same three: novelty, inventive step, and industrial applicability or industrial application. As I said, all formats of medical claims, such as method for treatment and medical first and second use claims, are allowed. The scope of protection is defined solely by the set of claims. The independent claim should recite a generic concept that reflects a purpose of the invention. And finally, for our favorite kind of subject matter, proteins and nucleic acids are only patentable if their function is established. Just claiming some protein with unknown function is not possible. Moving on to the nucleic acid. There are two major requirements for compilation of a claim. The first one is that the claim drawn to a nucleic acid should recite a function. In the two cases, this is defined in pretty much in the same way. It's a biological function, kind of activity or biological property possessed by the nucleic acid. As I mentioned before, naked claim like this, nucleic acid comprising the sequence listed in the sequence listing, such claim is not allowed. You do need to know the function. And the other requirement is that the claim should recite characteristic of this product, which allows for both distinguish it from others and actually characterizing it. In Russia and Eurasia, they distinguish between the situation where you do know the structure, like sequence. In that case, you list sequence and structural features, or you do not know. Then you have to recite physical, chemical, and other features that allow for distinguishing your compound from others. I'll illustrate this method throughout the talk. Examples. Patenting a gene, okay, and this is cancer. All my examples here, I guess, from cancer research. This gene was discovered to be a marker gene for determining cancer cell immortalization. So presumably it is overexpressed in case the patient has cancer. So this is the function of this gene, marker for determining cancer cell immortalization, and the rest of the claim is the description of this gene in structural and sequence terms. And another example is an RNA compound which downregulates the expression of gene p53 protein, which is a tumor, and the claim recites the exhaustive description of its structure, and of course, as I mentioned before, the function of this RNA compound. And finally, a set of primers for polymerase chain reaction, another example. And in this case, these primers are used to fish out a gene which is relevant for cervical cancer, I believe. And again, it is a set of primers for amplifying this particular gene, and the sequence information is here. Stands for the structural features. Two more things to add to this nucleic acid picture is that there is an extra legislation which requires that if a nucleic acid encodes some protein, it should be clear from the language of the claim what this protein is for. You cannot just have a claim where the nucleic acid encodes protein X. So in a real-life example, isolated nucleic acid encoding for product of M gene, we were requested by the examiner to add this underscored language, which explains what this M gene is actually for. The other thing is there are obvious ways to increase the scope of protection for your nucleic acid claim, which stem from the nature of nucleic acid. First of all, you may define your nucleic acid through, in case it encodes some relevant protein, you may define it through the amino acid sequence it encodes. In that case, you will unite under your claim all the numerous nucleic acid sequences which are generated due to the degeneracy of the genetic code, and even structurally unrelated, not really related sequences will be here all together because they all encode for the same protein. And the other two ways of doing increasing this scope is to mention the fact that your sequence hybridizes under such and such conditions of such and such stringency to some confirmed sequence, or that it has a some percent identity to some confirmed sequence. In addition to the nucleic acids being just the simple stretches of nucleic acid found in nature, you can also have genetic constructs. And genetic constructs are understood as combination of genetic elements obtained in vitro and in vivo, as well as organisms carrying it, like transgenic plant, transgenic animal, a host cell, or E. coli, for instance. In Russia, under Russian legislation, the genetic construct should be characterized in the same way as a mechanical device, by reciting the construction elements, building blocks, relationship among them, their location, mutual relationship, and so on. The simplest example relevant for our case is an expression vector, and you may know that the word expression is the only language for the function here, and it is acceptable. So you can get pretty broad protection for expression vector. So you describe the construction of the expression vector as a device just by sheer meaning, mentioning that it bears the nucleic acid from your. Another example, a large one, is a transfer vector claim. Again, transfer is the only indication of purpose which is found sufficient, and then exhaustive description of the structure of your transfer vector. Proteins. This will be easier because the same requirements as for nucleic acids apply to the protein subject matter. I'm talking about the necessity to indicate the function, activity, or property, and also indicate the structural features or physical, chemical, and other features. And I'll immediately illustrate these issues. Now, if we have established or partly established structure, which means we know sequences, then here's an example: an immunologically active fragment. Function is immunological, and then having cytotoxic T cell inducibility. And the description of the structure is the fact that it is a decapeptide, which means it consists of 12 amino acid residues, and its sequence is listed in the sequence list. Another example, recombinant interferon. Its function is that it has an antagonist activity compared to the wild type interferon, and then the rest of the claim is explanation of what it actually consists of in structural terms. And the third example is an immunogenic peptide against meningococcal infection, and here we define this is the function, and we define the structure through the percent identity to some central sequence, which presumably the applicant has confirmed the invention. If, however, we do not know sequence, we can still get a patent. In this particular case, from a real patent, the inventor has extracted the protein from the tissue. The protein was found to have an anti-tumor and analgesic activity when administered to humans, and it actually affects the tumors in a beneficial way. In this case, as I mentioned before, you need to recite physical, chemical, and other features. So for physical chemical features, we have the approximate molecular weight. And for other features, we most commonly use the features of the method of obtaining or producing the protein in question. In this case, we describe the extraction conditions. So this is sufficient for getting patent for this kind of subject matter. Very popular, perhaps the most popular subject matter when it comes to protein is an antibody. So I'll just have one slide to show what are the specific requirements for antibody. If the function, if the sequence information is present, then the minimal requirement is just the recitation of its function, which in this case is antigen specificity plus 6 CDR sequences. This is, I just drawn a generic claim. So human VEGF is the antigen against which this antibody has been raised, and there are 3 heavy chain CDR sequences and 3 light chain CDR sequences, and this is enough. However, as far as I know, in other jurisdictions, they, although reluctantly, accept antibodies characterized by just 3 out of 6 CDR sequences. In Russia and Eurasia, this is a big no, only 6. Only 6. If the structure is not known, this is another example. Interleukin 31 is the antigen, and this is the function of this antibody to recognize it. And for physicochemical and other features, we have the dissociation constant and the way this antibody has been raised by immunizing a transgenic animal. When the antigen is novel, you can actually get a broader protection in both jurisdictions. In Russia, you can have a claim like this. If, for example, is a polypeptide, the polypeptide of claim 1 is known, as it is in this case, then the antibody against this polypeptide can be claimed just in this broadest way. In Eurasia, it is the same thing. I haven't had any Eurasian claims of this kind, but I'm told that they don't even require to say in which way it was obtained. Final example of biological subject matter is a host cell, and for host cell you can get very broad protection as well. In this case, just say that host cell is an expression cell. Translating this to scientific language, it is capable of expressing exogenous genetic material. And there you only have to say that it bears the nucleic acid of your invention. And this is the sufficient language for getting this claim granted. Other kinds of subject matters, as I said, include method claims and use claims, all of which are allowed. And of course, for method of treatment claims, we need evidence which goes beyond demonstrating biological activity. But this is the point for another kind of presentation. But just know that it's not just as simple to get a method claim for drawn to treatment of human being granted if you don't have relevant supportive evidence. Another word of advice is it's always good to have a product claim, even if you didn't plan to do it. For example, if your invention deals with the use of a known product, there is still a word of experience that it's easier for the purposes of enforcing your patent rights to draw, it's better to draw a claim which is directed to a product. For example, by using the following scheme. Instead of having use of protein X as a colon cancer marker, you can draw a claim saying a colon cancer marker being or essentially being protein X, and then so on, the description of this. Sometimes this is suggested by the examiners themselves, that you should review the language because your particular motive is known. Substantive examination consists of issuance of 2 or 3 office actions which discuss the patentability, compliance of your invention with patentability criteria. And the reason why I mention this is that unlike Eurasia, where industrial applicability is rarely a matter, is really an issue, in Russia, they have adopted, in Russian Patent Office, they have adopted a very peculiar approach to assess industrial applicability. So, for example, for our European clients, it's quite often not a pleasant surprise. The Russian examiners are not that much concerned with the utility thing, because of course, like for example, if you patent antibodies, it is obvious that they will find their use in industry or can be industrially produced. So this is not an issue. What concerns them is how justified your claim scope is. What I mean is that, of course, there is a requirement of legislation that the implementation of the invention has to be shown, and I guess in this case it's close to the enabling thing. Your implementation of the invention has to be shown, but whenever the examiner sees that the scope of what you claim exceeds the scope of your experimental data, they will pretty much routinely issue a lack of support objection. And they will ask you either to restrict the claim to the scope of your experimental data or to present more experimental data. And of course, the requirement in legislation that you have to, the scope of your experimental data needs to match the scope of your claim. Because still the experimental data serve to illustrate the invention rather than to completely define it. On the other hand, and this is the industrial applicability is thus seen as a, how justifiable, how realistic is the scope of your invention in the light of the experimental data that you have presented and the knowledge of prior art, which often allows you for broadening the scope without further confirmatory experimental data. And I'll illustrate this with quite often in our protein nucleic acid claims, we have some central or confirmed sequence for which we have illustrated the implementation of the invention. Yet we claim, and we are entitled to claiming sequences which are around this central sequence, which is a nice thing, for example, to prevent easy circumvention of your invention. If the percentage is high, like 95% or more identity, even if the examiner, there are examiners who will still question, can you actually confirm that if you have a 95% identity, your invention will still work? And in this case, you can do without presenting further data restricting the claim, just solely by prior art-based argument. Because 95% means that at most 5 out of 100 residues, for example, in a 100 residue protein, are mutated. And of course, from prior art, we know very well that there are a lot of places in the protein which can be mutated, deleted, and modified, and so on, without any damage to the function, and hence to the invention in question. And in this case, we expect the examiner to withdraw his or her objection. However, if however the percentage is low, like 30 or 40%, and there are applications like that, 30 or 40%, I'm sorry, it's ridiculous. And we say to our clients that it's not realistic whatsoever. But if they're like 70, 80% identity, in this case you cannot justify, if you just have a central sequence, you cannot justify 75% identity to it without presenting more data. But one example will do. The examiner will not ask you for 10 examples. One example may actually completely solve the problem. So here I say that at least one example corresponding to the recited percent is needed. I'm done with the biotechnological claim drafting, and the final part of my presentation, I'd like to mention two things which are of interest as far as biopharmaceutical field is concerned. Time term extension, PTE. In the Russian legislation, some objects like pesticides and other chemicals require marketing authorization to be put on the market. And in accordance with the Russian legislation, if the time lapse between the filing date and the getting of first marketing authorization exceeds 5 years, you can get the patent term extended using the following formula. The time between the filing date and the receipt of first MA minus 5 years. The MA, the extension, the PTE cannot exceed 5 years altogether. And the subject matters which are in question are not only products, subject matters of compounds, composition, combinations, but also the use claims. But all the claims have to be tied to a product, to a particular compound or composition. For example, methods of treatment or kits are not discussed here. Only these kinds of claims which are listed. As far as Eurasia is concerned, it goes to the national legislations, and all but one contracting states have a corresponding legislation, so you can get extension in all but one contracting states. The other slide for this topic is necessary documents. I forgot to mention that you don't get the patent term extension automatically. You need to apply for it. So, I mean, the application needs to have the actual application, official fee, notarized copy of the first MA, and then indication what patent claims are in question corresponding to the MA. And finally, you have to present some sort of evidence that will convince the office that the product mentioned in the marketing authorization is the one mentioned in the patent claims. So this is not a closed list from some structure obtained from some structure register from pages from some encyclopedia, instructions for therapeutic use, to some really elaborate and tricky documents. As far as data exclusivity protection is concerned, this is another of the two topics with which I wanted to finish my part. As some of you may know, last year Russia has joined the WTO, and as a consequence, Russia had to bring its legislation into harmony with that of the WTO. And in our Russian law on circulation of medicaments, we now have this clause, Article 18.6. which deals with the data exclusivity protection. Data exclusivity is understood in the same way as elsewhere, that it is exclusive right of the applicant to use the experimental data for obtained for registration purposes. And this legislation reads that what is prohibited is obtaining this use for the purposes of registration of information on preclinical and clinical studies provided by the applicant for registration. This cannot be done without the applicant's consent and during 6 years since the initial registration. So 6-year term, I know that in some countries, like for example in Europe and the US, there is like 8+2+1, I believe here is just 6-year term, and the legislation does not prohibit registration as such, rather it restricts the legislation. There are no regulations yet as to the way this law should be implemented, and let alone any practice. However, the important consequence is that there will no longer be accelerated registration for generics. It used to be like that all we have to do is to carefully cite the experimental data for the original medicament. Now it's no longer like this, and in real life you can register generics only after since 6 years, 6 years since the registration of the original document. I'm done with my part of presentation, and let me give the floor to Evgeny, who will discuss the legal issues.
Hello everybody, my name is Evgeny Alexandrov. I'm a chief lawyer at Gorodissky and Partners law firm. And my part of presentation is dedicated to the issues relating to enforcement of patent rights in Russian courts. And first of all, I would like to start from introduction to the Russian court system and tell you a few words about structure of the Russian courts. Basically, there are two main branches of the courts in Russia. One of them is a commercial court branch, and another one is a common court. The basic difference is that common courts deal with those disputes in which individual persons are involved. Commercial courts handle disputes between legal entities and private entrepreneurs and persons involved into the economic activity. As you can see on this slide, there is a division in the part of commercial courts, which is the intellectual property rights court. That has been recently introduced in the Russian court system. This court will handle intellectual property disputes only as the court of first instance and the court of cassation instance. As regards the legal acts regulating the intellectual property issues, you can see on the screen just a few of them that are totally applied in Russia, and the main legal act is the Civil Russian Federation, and it's part 4. It's a code on administrative offenses and criminal court dealing with violation of intellectual property rights, protection by the law enforcement authority like police, and the law protection of competition, which can be applied if there is a matter of unfair competition. Just a few words about the intellectual property court, because it's quite new for Russia. It is supposed that the court will have a special department of consultants who will have a special technical background, who will be specialists in particular fields, and will advise or consult the judge right during the hearing. And in case the judge will have some technical issues, questions. At that, if the judge finds that this service of consultant is not good enough, the court may send a request to an independent specialist or a special organization and raise some certain issues before the expert or specialist. Besides, the court still will have an opportunity to order for independent expertise and entrust it to a particular specialist in a particular field. At the present, suppose that the judges will have special technical background, but there are some plans that special educational system will start work for training judges who will be experts both in legal and technical fields. Here you can see the cases to be handled by intellectual property court. As I said, the court will handle the cases as the first and cassation instance, and no appeal instance will exist in this system, in this court. And as a first instance, the intellectual property rights court will handle appeals against decisions of the patent mark office, some kinds of validity actions, non-use cancellation actions, and some other disputes. That the decisions of the first instance court may be appealed to the cassation instance. The decisions of cassation instance may be appealed to the Supreme Commercial Court of the Russian Federation. As regards IP rights infringement cases, the situation is quite different because the infringement issues and cases will be still handled by regional courts at the location. The lawsuit may be filed at the location of the infringer. Then they may be appealed to regional court and to the appropriate appeal court. And after that, the decision of the Court of Appeals may be appealed to the cassation instance, to the Intellectual Property Court. So as you can see, this court will be in an instance handling all intellectual property disputes, and it will help to unify the court practice in the intellectual property field. As regards the remedies that can be claimed through the civil proceedings, those are recognition of right, cessation of activities infringing the right, and as well compensation depending on the subject matter involved. As you can see, that the compensation nowadays is available with respect to trademarks and copyright only. As regards patents, such rule is not enforced yet, and there is only draft bill being discussed in the Russian Parliament, and it's quite possible that in the nearest future we will have a possibility to claim compensation for infringement of patent rights in the Russian courts. Besides, it will be possible to claim seizure or destruction of products infringing the patent or equipment which is used for producing the infringing product. As well as the Russian law provides possibility for such claim as publication of court decision and at the register of the Russian Patent Office, and liquidation of legal entity which committed the repeated infringement of intellectual property rights for the same IP subject matter. Basically, conditions for patent infringement are provided by the civil court, and it says that a patent owner shall have an exclusive right to use the patented invention, utility model, or industrial design, and at that any third party which is using the patented invention or utility model or industrial design without consent of the patent owner shall be considered as the patent infringer. It should be noted that we do not have contributory infringement in Russia, opposite to the United States system, but we do have direct and indirect infringement, which means that a product obtained by a patented method or process also infringes the exclusive right of the patent owner. At that, it should be noted that under the Russian law, a patented invention is deemed to be used legally or illegally in the product if each and every feature of the invention mentioned in the independent claim of the patent is used in the product or a feature equivalent to it. At that, under the Russian law, the following actions shall be considered as infringing the exclusive right. The manufacture of the product, the use of the invention, implementation of the invention, or importation of the, or offering for sale or selling the product in which the patented invention is used, as well as the use of a method or process protected by patent or the offering of it. How we deal with patent infringement, and one of the options is sending a warning letter to the infringer. Sometimes this option indeed works, especially in those cases when the infringer has any idea about existence of patent right to a particular subject matter. But in many cases, infringers perfectly know about existence of patent rights, but they still produce the products and using the patented invention. And in this case, warning letter cannot work. And in this case, the patent owner will have to seek some other options, for instance, filing a complaint with the police or filing a lawsuit with the civil court. In some cases, it's really not advisable sending a warning letter. For instance, if the infringer knows of the existence of patent rights, he may undertake some steps and hide the infringement, for instance, change location of the product or change its scheme of distributing the product on the market. That make it difficult to secure evidence of infringement and initiate legal actions against such infringers. After the product infringing a patent has been revealed, the first step that should be done is conducting an health examination of the product, just to be sure that the patent is indeed infringed by a particular person. After that, if the infringement is confirmed by the in-house specialist or a patent attorney, it will be possible to choose whether to file a complaint with the police or go to the court and enforce patent rights. In this case, it's the most important issue is securing evidence of infringement, because if there are no evidence which could be sufficient under the Russian law, the claims may be simply rejected by the court. And therefore, you should know about options available for securing evidence, which allow to secure evidence in such a way which will be acceptable from the point of view of procedural rules of the Russian law. It should be noted that no discount treatments are provided by the law, and therefore the patent owner should secure evidence himself or by ways which are provided by the law. For instance, there are different ways of collection of evidence. Some troubles with the presentation. So oh, it still doesn't work. Oh, yeah, that's fine. So first of all, the first option is just to simply purchase the counterfeit product from the seller. It sounds very simple, just or to order from the internet shop, and just to have the product, just to sue the seller. But in this case, it may be quite difficult, to prove that infringement takes place, especially if you have just a simple receipt from the seller. And sometimes a receipt contains no enough information just to simply identify the infringer and identify the product. For instance, the receipt may contain information about just a brand and a product, like Sony camera. That's all, without mentioning the concrete model. In this case, you can imagine that the Russian court will not be able to identify the concrete model in which it is supposed that the patent is used without consent of the patent owner. Therefore, such test purchase may have no positive results. In such situations, it is possible to involve a private investigator who is a professional in this field and may arrange a test purchase and obtain necessary documents which shall allow to identify the product and ensure and secure evidence of infringement. Very often we use services of a notary public. who can go with us to an exhibition and make some photos of the exhibition and make photos of the infringing product, as well as some catalogs and other materials. And this certified by notary public evidence can be used as sufficient evidence of the infringement in the Russian court. If it is not possible to collect evidence just by way of purchasing or in the exhibition or other ways, it would be possible to file a lawsuit on the basis of a piece of information about the infringement, and then ask the court to request particular documents and evidence from the infringer. And according to the law, the infringer must provide the court with the requested documents. And the last option is collecting evidence within the frames of criminal or an administrative case. Of course, you can imagine that sometimes it's quite difficult to enter the enterprise or plant of the infringer and get access to some documents or equipment. In this case, it's possible to file a complaint with the police, and they will conduct a raid on the premises of the infringer, and then collect some documents which could be further used in proceedings in litigation against the infringer. Further, it's good to know that in Russia we have now an electronic justice system which was introduced a few years ago, and this system allows to submit all documents, including the lawsuit, with the court electronically. So there is no need more to go to the court in person. Besides, this system allows to monitor developments in the case and get updated information about all documents filed by the parties, and as well as about judicial acts issued by the court. Also, electronic system allows to participate in court hearings online using the video conference system. It is especially useful when you have a trial. When you have a trial in the, for instance, 9,000 kilometers from Moscow, and you need to go there and spend the client's money for a business trip, and therefore it is quite easy to go to the Moscow court and have a video conference with the court located so far from Moscow. Therefore, this system allows to reduce expenses of the client for the litigation. As regards the court hearings, so there are two stages. One of them is the preliminary hearing, and this stage is very important because exactly at this stage all parties must open their evidence. Besides, at this stage the court will decide whether the independent expertise is required or not. That the Russian judges do not have a special technical background, and therefore they cannot resolve technical issues. And in this case, very often the court orders for independent expertise. According to the Russian law, the expertise may be entrusted to an expert organization, or to an individual expert, or to a group expert. As regards the experts themselves, so the courts do not have a list of experts, but the parties shall have the right to propose their experts. For instance, if they have information that there is a person very well qualified in a particular field, and his skills and knowledge are required to answer specific questions in these proceedings, so they may propose such expert to the court. Besides, the parties may propose questions for experts, and in case they have information that the expert cannot conduct an expertise for some certain reasons, they may challenge such an expert. As soon as a report from the expert is submitted with the court, the parties can prepare and submit their opinion with respect to conclusions of the expert. And in case there are some discrepancies or the expert's report is not well grounded, so the party may ask for a new or repeated expertise. Besides, it is possible to ask the court to invite the expert to the court hearing and ask some questions to the expert. As regards the payment, so the burden lies on the party who filed a motion for independent expertise. At the main hearing, the parties produce their evidence and arguments. Then they examine together with the court the report of the expert, and if the court, the judge has some questions, he may ask to the parties, and then the decision will be announced the same day. So some practice examples which could be more interesting for you, and one of the case relates to patent infringement. In this case, a patent owner filed an infringement action against a Russian company, which was going to obtain a marketing authorization for a product for the purpose of selling of the same product. And during the court proceedings, the court ordered for independent expertise, and according to conclusions of the expert, the patented invention was used in a product described in technical documents filed for registration of the product with the Russian authorities. Therefore, having applied such formal approach, the court of first instance satisfied the lawsuit, and the court of appeals and the court of cassation upheld the decision of the first instance court in force because it was in full correspondence with the Russian law from the formal point of view. And the defendant filed a supervisory appeal with the Supreme Commercial Court. And the Supreme Commercial Court, having analyzed all the documents and circumstances surrounding the case, decided that actions of the Russian company can be qualified as preparation for use of the treatment after expiration of patent rights. And according to the Russian law, such actions as conducting of an experiment with a product can be considered as a patent infringement. And therefore, the court decided that the company, by way of filing documents for registration of treatment and for the purpose of obtaining a marketing approval, actually didn't infringe the patent rights. However, there still will threaten of infringement of patent rights in future, because after any marketing authorization, the company will have the right to introduce the treatment on the Russian market, and which is prohibited under the Russian law until the patent is valid. And therefore, the Supreme Commercial Court decided to prohibit the Russian company producing the treatment except those cases when producing of samples is required for the registration process. There are two other topics which I would like to tell about. One of them is a file reference topic, and I must say that the Russian law actually doesn't provide such file reference topic doctrine. And therefore, there are no regulating this issue. However, I will talk about this in view of the recent court practice, which actually is a precedent case in which a Russian company became the owner of patent for an invention for a vaccine in the year 2003. The vaccine was elaborated based upon particular antigens produced by cultivation of Hansuella polymorpha yeast strains. And in the year 2006, so 3 years after, an Indian company, Serum Institute of India, introduced on the Russian market a vaccine of the same nature, and this was there was information that the vaccine was also elaborated based upon particular antigens produced by cultivation of the same yeast. And since that there was no information in the package insert about a particular strain producer, the Russian patent owner decided that probably the same yeast strain was used, and therefore a patent infringement takes place. So the court of first instance ordered for independent expertise, and the experts came to the conclusion that the vaccine was produced by cultivation of the same yeast cells, but there were different strains used for production of this vaccine, and therefore, on the basis of the expert's opinion, the court of first instance dismissed the case because it also applied a formal approach and decided that if in the patent there are particular yeast strains mentioned, and if the defendant uses a different yeast strain, therefore infringement doesn't take place. But the Court of Appeals and the Court of Cassation reversed the decision and satisfied the lawsuit because, in the opinion of the courts, using different yeast strains can be considered as equivalent features, and therefore such actions as importation and distributing the products should be considered as infringement of a patent and therefore prohibited. Taking into account that the Indian company started selling the products before the priority date of the patent, they filed an invalidation actions with the Chamber of Patent Disputes. But the Chamber of Patent Disputes haven't considered the materials and documents, rejected the invalidation actions of the Indian company. Therefore, the Indian company filed a supervisory appeal with the Supreme Commercial Court, and the Presidium of the Supreme Commercial Court, having examined the case, came to the conclusion that, first of all, the Indian company started produce this vaccine with using the same antigens since the year 1999. And the second issue, vaccine was imported into Russia by another Russian company. Therefore, at least the lawsuit was filed to a wrong defendant, as the Indian company itself didn't import the vaccine into Russia. And finally, the patent vaccine was new and patentable because the applicant proposed new yeast strains that hadn't been used by other producers of vaccines. Besides, first time in the whole court practice, the Supreme Commercial Court looked into the patent files and noticed that in the patent application, the Russian company, patent owner, clearly stated that the yeast strains used in the production of the vaccine under the invention were new, unknown in the prior art, and were never used by other producers of such vaccines. And therefore, and besides, the novelty of the invention was confirmed by the decision of the Chamber of Patent Disputes, and with consideration of information provided by the Indian company. And therefore, the Presidium came to the conclusion that the invention wasn't used in the vaccine produced by the Indian company, and therefore the patent wasn't infringed. And of course, the Supreme Commercial Court reversed the decisions of the court and rejected the claims of the Russian patent owner. One of the important issues is preliminary or interim injunctions. The Russian law provides possibility to claim or request for injunctions during the court hearings until the decision of the court is issued. And the patent owner can claim seizure of property or monetary funds. For instance, if there is information about storage, about concrete location of the warehouse where the infringing products are stored, it is possible to claim seizure of those products. Besides, it's possible to ask the court for a ban on performing certain actions by the defendant. It could be, for instance, selling the product until the decision of the court is issued, and other injunctions are available. And however, according the law, of course, provides such options, but it's from the standpoint of the Russian court practice, it's quite difficult to get injunction from the Russian court. And now practice and the whole Russian practice in the pharma field, we've had just one case and one example when we managed to get injunctions. In this case, there was infringement of a patent, and which was for a method of treatment, and there was a product, a generic product produced by infringer, and we got information about the warehouse where the product is stored, and therefore we filed a motion with the court and claimed injunctions and for seizure of the product, and we succeeded in this action because we actually put much effort for it. We didn't simply file the application, which is usually done. We supported our application with many documents confirming the infringement, and also attached an opinion of an independent expert confirming that the infringement takes place, and therefore we succeeded in this action. So as you can see from this brief presentation, the Russian law provides many options for efficient enforcement of intellectual property rights, especially in view of introduction of new intellectual property court. We do hope that the Russian court practice will be well unified, and it will help the right holders to more efficiently protect their rights in the Russian court. So we have come to the end of our presentation for today, and thank you all for participation in our online webinar. And if you have some questions, we have a few minutes. Also, you can send your questions to our emails, and we'll be happy to answer them. So if there are no questions, or you need some time to think about it, you can send the questions to us by email. So thank you very much for your attention, and have a good rest of the day. Thank you. Goodbye.